In connection with appeal for the first. Wait for
Lordship, assigned matter, Lordship. Assigned matter missed last occasion, Lordship.
Which one?
Lordship, I have mentioned, Lordship directed me to wait for after 70, it will list.
Well, at appeal hearing and bail in connection with appeal and modification.
My lord, may I be permitted to mention? Your lordships, kindly to mention this is an original site land matter specially assigned to your lordship's matter. Lordship, the interim order is expiring on 29th November, your lordship. I was humbly praying if you can
Keep it on 29th. We keep it on 29th.
oblige your lordship.
Thursday, Friday we keep matters.
Lordship, if it kindly
Friday
kindly
it will
keep
come.
on Thursday,
Why? Friday it will come.
oblige your lordship.
May I be permitted to mention one bail in connection with appeal?
May I mention, Milord mentioning upon notice original site assigned matter, Lordship.
Friday.
Right.
My
State advocate name is missing in orders.
Name will be incorporated.
My lord,
Yes.
may I be allowed to comment? My lord, this is a matter, this is a criminal appeal against Calcutta. It is pending since 2019. The paper book is ready and we have been engaged by State Legal Service Authority on behalf of petitioner. The
from bail in connection with appeal, my lord.
Call the list.
Well, the 1 and 2 may be taken up together, while the proceedings has been quashed. Well, these are the
Quashed. Accordingly, application is disposed of as in
practice. Grateful, man. 1 and 2, madam.
one.
No.
1 and 2. Well, give the order. Just keep it on record. Yeah. Order sheet दी दे. Sir, order sheet लेके ना. Order sheet.
Oblige.
Yes, next matter.
एंकर पे ये. एंकर पे ये.
Yes, Mr. Ganguly.
ठीक है. आराम से.
But pursuant to your lordship's direction, the victim is personally present, lordships.
time for the petitioner. Lordship, my submission was that the boy and the girl, they both committed suicide from the same tree branch. They were hanging. Girl's parents filed.
Report of the boy.
Boy.
Same antibody hanging by an antibody in nature. Yes.
That is not in the FIR. Mother
But in the
never
FIR
said
FIR
anything.
says lot of things. Not FIR. This is the case diary.
No, we are all sisters of the boy. All married sisters of the boy. Boy was youngest. They are all elder married sisters. Married sisters.
No. No, no, no. मतलब ছেলেটার নাম গৌতম 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 and মিলি
Millie.
Petitioner number 2 is the mother, my lord.
Petition. Yes.
On the constantly it appears. Sisters.
I'm highly obliged. Sir.
For the petitioner. Directed to husband's surrender.
My lord, husband could not
Directed to
surrender.
husband surrender last week, he did not surrender till today. Get. Yeah. Application, my lord, directed to file a medical report.
My lord, there is a medical report attesting to the fact that he was admitted to the hospital, but as far as the degree of injury is concerned, there are no specifications, my lord.
But these are the medical reports.
These people are occultists, my lord, who have been duping people in the neighborhood for a long time.
The extortionist. Huh? We have considered the materials on record.
Case and counter case, my lord, is there.
What counter case is there?
Sir,
You
this case
people
is the
go
counter-
there and you say that you
to grab
give
the-
money, otherwise we will
No, my lord.
do puja for your death, and then
to
when they
grab the
protest,
property, my lord, to grab the property of the petitioner, my lord, the case has been first
grab the
entered.
property.
Lord,
of-
kindly see, my lord, page 10.
Where
my
is your counter case? Let us
Yes,
see
my-
your counter case.
Lord, kindly see page 10, my lord. We have stated, my lord, 3rd, my lord, October, my lord. I have filed. To grab the property. Case has been, my lord, filed. De facto complainant is the lucky, my lord.
This is on 19, and the incident in your case is of July. The incident in the FIR is October.
Yes, 3rd October.
Huh. Petitioners submit that a criminal case had been lodged against the de facto complainant in July 2024. In retaliation, he has been falsely implicated. Full stop. He prays for anticipatory bail. And a lawyer for the state produces the case diary, including medical reports. We have considered the materials on record. There were disputes and differences between the petitioner and de facto complainant. An earlier criminal case had been registered against the de facto complainant. Full stop. Though victim was de facto complainant was hospitalized or another person.
The de facto complaint was hospitalized.
Though de facto complainant was hospitalized, the injuries do not appear to be grievous. Under such circumstances, we are inclined to grant anticipatory. One of the guys is transferred. Next.
May it please your lordship. My lord, dispute between two persons regarding the relationship with a girl, my lord, which ultimately escalated into a free fight. My lord, case, counter case, both parties sustained injuries. Two of us sustained, my lord, fracture injuries in the head, who received 5 stitches each, and one sustained, my lord,
There are three injured.
2 stitches.
Three
This is
injured
our counter
witnesses.
case.
This is the first injury report, my lord, of Mohammed Shamir. Second injury is at page 18 of Anisur. The third injury is at 19. My lord, fracture elbow, scalp injury, lacerations on the head. There are three. The injured persons were also examined after 10 days because they were in the hospital.
You have
My lord,
considered in our case, they have already been granted bail.
Huh?
Charge sheet has been submitted, and in our counter case, my lord, they have already been granted bail.
You surrender. Total, there were 12.
We have considered the materials on record. Statements of the injured implicate the petitioners in the assault. Injured persons suffered grievous and injuries, including fracture. Hence, we are not inclined to grant and substitute.
Next.
Also, cases of 302. In this case, FIR against 59. Your lordship has been pleased to grant bail to 24 accused person,
Yes.
26, and rejected.
Your lordship, sir, please to direct me to check, my lord, the oral dying declaration, my lord, page 10, my lord, Usman Sheikh, named petitioner number 2 and 1. My lord, page 11, my lord, Tafijul, named petitioner number 3. My lord, Kabil Sheikh, my lord, named petitioner number 2 and 3.
We have considered the materials on record. Statements of witnesses before whom oral dying declaration was made show implicate the petitioners in the murder. Full stop. They do not stand in the same footing with কি যেন? They do not stand
Stab Israel, so many persons, 26
in
has
the
been granted.
same footing as Estab or Israel Sheikh, who have been granted ancillary bail. In such, in view of the nature of the gravity of the offense and the nature and the involvement of the petitioners therein, we are not inclined to grant that. Next.
There, Mr. Rai will be appearing in this matter, and I'm praying for not to down. He's not
What
ready
is
with
the offense?
some food
466.
ready and land grabbing is there. But so yeah, but antecedent regarding antecedent of that person, we didn't get any instruction from police. So kindly take it up tomorrow, madam.
জানোটা তারই কথা বলে করো শুধু ল্যান্ড গ্রাবিং হ্যান্ড হ্যাঁ তুমি দেখেছো the order by party what is in the civil appeal. Your lordship had occasion to deal with this case when the promoter was granted bail by your lordships.
Who are you?
But I am the grandson of the pastoral owner, Bhuvan Mondol. Bhuvan Mondol was my grandfather. I have a share in the property, myself and the other heirs of Bhuvan Mondol. We engaged a developer called Biman Bhattacharya.
Today. Biman is in bail.
Biman is on bail. And I will also take your lordship to the orders passed by the civil court in appeal.
ওইটা লক বলেছে আমি বলছি এটা 11টা বোধহয় নষ্ট
So, কি হলো?
এটা কি ফ্রাইডে
Mr. Rai,
I'm not ready, my lord.
tomorrow.
Tomorrow.
Item number 12, madam.
But I'm for this.
On 1st June
2024, on the date of election, the petitioners were restrained from giving agent in the polling booths. Due to that, a commotion took place. There was a case and counter case, and the counter sections are almost same. Nature of the complaints is almost same. They have got anticipatory bail from the trial court, and one of the petitioner, the application of the petition was rejected by the district sessions judge. And my lord, one of the accused in this case has been granted bail by the lower court.
My lord, in this matter, my lord, 8 stitches were given. My lord, 7 days he was hospitalized. My lord, in this matter, my lord, petitioner number 1, 2, and 3.
Both groups fought.
My lord, that has been charge sheeted under section 323.
That is because that group is close to the political executive.
My lord, but in this case, my lord, there is severe injuries.
No, correct. Injury is undeniable. Who is the author of the injury?
My lord,
One
petitioner
group
number
which
1,
is
2, and
favored
3.
is 323, another group is 307.
My lord, the investigation is going on, my
Now,
lord.
let it go on. Petitioners submit that there was a fight between two political groups. Case and counter case was registered. Co-accused have been granted anticipatory bail. They pray for
Bail, my lord.
have been granted bail. Then you should also get bail. Why should you get anticipatory?
But other group, on the date of incident, a person was arrested, and he was not there even. The person who was
Maybe,
arrested.
My lord, nobody was
But
granted
other groups, they have been granted anticipatory bail, my lord.
where are the orders of
Right, my lord. I have annexed.
That is what we are saying. Other
have
group
annexed.
has been given anticipatory.
Other group. My lord, the reflection of the order kindly comes to page 25, my lord.
Co-accused,
It starts from page 23.
Co-accused কেটে দাও। Persons implicated in the counter case have been granted anticipatory bail. They pray for similar relief. Learned lawyer for the state submit. Police personnel were severely injured and hospitalized. Charge sheet has been filed under section 323 IPC in the counter case. In the other case, we have considered the materials on record. On the day of election, there was a fight between two political groups. Petitioners belong to one group, while the accused in the counter case belong to the other group. In the investigation, though the FIR in the present case, has been registered under graver offences, including attempt to murder, the charge sheet in the other case has been filed under section 323, filed under section 323 IPC only. Full stop. This gives an impression of biased investigation. This gives an impression of biased investigation, and this court biased investigation. Full stop. When offences are committed in the course of a free fight between two groups, it is the duty of the court to distill the materials on record and determine the specific role of each individuals. Examining the statements of witnesses from that perspective, we note that the said statements are generic and non-specific with regard
to the assault, full stop. Possibility of implicating members of one political group and exonerating the other in the attack on police personnel cannot be ruled out, full stop. In light of the aforesaid circumstances, we are inclined to grant anticipatory bail to the petitioners, 10,000 to sureties, meet officer in charge once in a week on the protocol.
One indulgence. My lord, there was no attack against the police personnel, my lord.
Then who were injured?
My lord, individual person was
Both
injured.
parties. Individual, the police together.
And my lord, 341 and 506 are also there.
Because 188, etc. are there, na? That's why we said. No police personnel was
No
injured.
police
Okay.
Grateful.
If
My lord, I'm for the state, my lord. My lord, I'm just received the case, sir.
Section.
Case of 302, the victim was alive for some days before
Let
the
us see the statement.
victim was alive from
Give
some
the
days.
FIR to us.
My
There
lord,
is
proclamation is attached against the petition.
Proclamation is attached.
that
Proclamation and attachment under section demo, just now.
Which comes first, attachment or proclamation?
CD is here, my lord.
No, we are asking you. CD does not speak of law. CD speaks of fact. We are asking a question of law.
My lord, proclamation.
Which proceeds first, attachment or proclamation? Attachment proceeds first. Let the public prosecutor be present here. Where is the public prosecutor?
My lord,
We need to have classes for empaneled public prosecutors.
My lord, proclamation.
Please don't appear and seek to defend the state, and you are not only representing state interest, you are representing interest of an individual. Try to learn the law and come. It is warrant. After warrant, there is a proclamation. If the proclamation, the arrest doesn't take place, within 30 days, there is an attachment. Right. So you are proclaimed offender.
no, my lord, I have challenged
Yes,
that
now
order.
let us see the case diary.
My lord, that was challenged. The order of proclamation was set aside. Thereafter, my lord, I have filed this application. My lord, kindly see the charge sheet says about that there was a dispute between the family. Multiple litigations are there. My lord, it is said that this was only fist and blows. My lord, kindly see it is also admitted that the lady was ill somehow. My lord, she was alive for some days before the hospital. My lord, kindly see her statement whether, my lord, there is anything, my lord, aggravated to, my lord, to kill her. Nothing like that. My lord, during a Durga Puja, my lord, between the Sopinda, my lord, this thing happened. My lord,
We
admitted.
have considered the materials on petitioner contents that there is prior enmity between parties. Case and counter case are pending. On the day of incident, there was a minor scuffle. Victim survived for how many days?
Well, for 5 days so far, for 5 days in the hospital.
For 5 days. Accordingly, they pray for anticipatory bail. Learned lawyer for the state opposed the prayer. She contends that petitioner is a proclaimed offender. In response, it is contended that the proclamation and attachment has been set aside by a bench of this court. We have considered the materials on record, including statements of witnesses. Witnesses implicate the petitioner in assaulting the victim. As a result, she was hospitalized and died. Postmortem report shows internal injuries in the brain and fracture of ribs. It cannot be said, in view of the nature of injuries, it cannot be said that the assault was slight or was slight. Accordingly, we are not inclined to grant anticipatory bail. Rejected.
14, I beg to appear on behalf of the states.
To me. Well, a 17-year-old boy fell in love with a 16-year-old girl. Biplab Das. The present petitioner happens to be the brother-in-law of Biplab Das.
Babu.
My lord, the Babun Das. My lord, your lordship, please see the last part of the certified copy which I have annexed, where the lady,
Girl committed suicide.
the girl committed suicide. Both are minors. And it is admitted that they were in a relationship. I am the brother-in-law of the main principal accused, if we may call him.
Lord, kindly see, my lord, page number 16, 17, and 18. Those are, my lord, independent witness about the Raqqa spot at the 11 o'clock at the night. We have the eyewitness of that incident.
Normally, my lord, I don't go in for alibis, but I am a employee of State Electricity Board, my lord. I've given that I was on night duty on the 1st of September. That's I've given, my lord. I'm just happened to be the brother-in-law of the principal accused. Nothing more, nothing less, my lord. Both are minors, my lord.
Petitioners submit that the victim girl had developed a relationship with the petitioner, with relationship with one
Biplab Das.
Biplab Das, brother-in-law of the petitioner. He committed suicide. Petitioner was not present at the place of occurrence. He prays for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Statements of witnesses allege that petitioner and others came to the residence of the victim and threatened to kidnap her. Full stop. This allegation requires to be credibility of the allegation has to be taken into consideration, has to be assessed in the light of the defense version that there was a romantic relationship between the victim and Biplab at the appropriate stage of the proceeding. Full stop. Victim had not left behind any suicide note implicating the petitioner. Petitioner contends that he was not present at the place of occurrence and was he was at the material point of time discharging his duties at his place of work. Full stop. In view of the aforesaid circumstances, we are of the opinion petitioner may be granted anticipatory.
Grateful.
I am for the petitioner, Lordship. Kidnapping conjointly, there was a business relation allegation that a boy was kidnapped. Subsequently, the boy was recovered. Lordship may say the statement of the boy.
They were recovered from
We
the
have
house.
considered the materials on record. Petitioners had kidnapped a young boy and demanded money.
Two of them were kidnapped, Your Lordship.
Two boys
Two boys.
and demanded money. In view of the nature of the crime, we are of the opinion this is not a fit place to grant anticipatory.
Much obliged.
Yes.
I'm not the same.
The allegation was filed against the 7 accused persons. I am for the 2 accused person, but the allegation is that the de facto complaint under husband was running business in the store. Now, the accused person used to collect this
Simple
money from
injury, my
people's
lord.
store?
We have considered the materials on record, allegations, injury report shows the injuries are simple. In view of the aforesaid fact, we are of the opinion custodial interrogation is not necessary and petitioner may be granted answer. Next.
May it please the Lordship, I am for the petitioner. 1 year of marriage, husband is in custody, 498A, 304B. All are married and unmarried sister-in-laws of the alleged victim.
They used to torture for demand of more dowry within 1 year of marriage.
We have considered the materials on record. Statements of witnesses implicate the petitioners in the torture of the housewife who was compelled to commit suicide within 1 year of marriage. In view of the nature of offense and prima facie involvement of the petitioners, we are not inclined to grant answer.
Okay.
Next. I'm planning to start a dog park.
My lord,
Ali Das.
334, charge sheet submitted.
300?
306, 34. Lordship, the man committed suicide.
Paramar.
Lordship, they both
She is
married.
a married woman.
Yes.
You are a married woman.
Yes.
And
He is also married.
he is also married. Then
And my
I commit suicide.
husband got
Get a
anticipated.
divorce. Petitioner submits that. This witness should be prosecuted. They forced this boy to marry some girl, and now the boy committed suicide. Then petitioner submits that the victim had committed suicide out of depression. Ingredients of the offense under section 300, under section 108 of the BNS are not disclosed. She prays for answer. And a lawyer prays, opposes the prayer. We have considered the materials on record. Victim is a relation of the petitioner. Victim is the brother-in-law of the petitioner. There was an illicit relationship developed between them. Subsequently, he married. Thereafter, Thereafter, he committed suicide. No suicide note has been left behind by the victim implicating the petitioner. Under such circumstances, we are inclined to grant bail to her. Next.
Petitioner, my lord, the allegations are under section 85, 115, subclause 2 and 109 of the Bharatiya Nyaya Sanhita, my lord, and 3, 4 of the Dowry Prohibition Act, my lord. My lord, 1 year of marriage. But the complainant wanted to live separately with her husband, your lordship, and that
We
is
have
why she
considered the
falsely.
materials on record. Allegation of torture. We have also examined the uh, uh, injury report. No external injury mark is seen. Full stop. Allegation of physical assault has to be assessed in the light of the aforesaid circumstances at the appropriate stage of the proceeding. Other allegations of cruelty are general and omnibus. Uh, Accordingly, we are inclined to grant anticipatory bail subject to condition. Petitioner number 1 shall meet investigating officer once in a week and further.
Great,
One
my lordship.
দরকার নেই, একটাই আছে।
Sections are under, my lord, sections 498A, 304B, 306, and 34. Now, the principal accused have already been enlarged on bail after, my lord, 100 days of custody. And, my lord, at that apart, my lord, I am the mother-in-law.
How
of
many
the
years
victim.
after marriage?
Within 2 years, my lord.
Huh?
Not within 2 years of marriage.
Within 2 years of
But
marriage.
within 7 years, not 2 years.
His complaint is stated 2 years.
For 2 years? My lord, it is 2 years. But the husband and the father-in-law have already been enlarged on bail. I am the mother-in-law. My lord, no specific allegation against me. And my lord, I am the only one who is taking care of the child. There is a child.
Petitioner submit that the principal accused, that is the husband, is on regular bail. Petitioner is the mother-in-law. She prays for anticipatory bail. Learned lawyer for the state submit. Victim housewife was tortured over demand of dowry and committed suicide within 2 years of marriage. We have considered the materials on record. Principal accused, that is the husband, has been enlarged on regular bail. Petitioner is the mother-in-law. Allegations against her are general and omnibus. Under such her custodial interrogation for progress of investigation is not necessary. Accordingly, we are inclined to grant answer.
Charge sheet has been submitted.
Now, investigation is complete. Accordingly, we are inclined to grant answer. Our custodial interrogation is not necessary. Huh? Next.
It's for deeply obliged.
The petitioner lords. First allegation are 498, 307, 406, 34, and 348.
But there is a 16 after 6 months of marriage, my lord, they
Three-
started torture.
3 months.
Injury.
No injury. my lord.
Lord,
Medical.
we have considered the materials on record. Allegation of physical assault is not supported by medical evidence. Other allegations of cruelty are general and omnibus. Under such circumstances, we are inclined to grant answer. Next.
Wait, please, Lord. My lord, the 2 trucks full of sand were seized by the investigating agency, my lord. My lord,
Sand mafia.
I am the owner of the trucks.
Ah.
But
No,
sand have been seized.
My lord, certain e-challans were seized inside the truck. My lord, we have sent before the BLRO. The BLRO has already confirmed those are all fake challan. Now the truck belongs to him. The statement of the co-accused who happens to be driver said, as per the instructions of this gentleman, my lord,
What is the royalty on the
CFT has not been, my lord, stated in the.
find out the royalty, huh? State shall submit report with regard to royalty payable on the sand seized from the petitioner's truck. Matter will appear 1 week hence.
My lord, but not to take what
Antecedent also. Huh? What not to do? What are you saying? We don't understand.
not to take
He's
any
asking
coercive
for
measures.
protection.
This
Protection.
in a
Don't
week.
arrest. Thing is, also sees antecedent. If any other criminal report with regard to criminal antecedent shall also be.
Grateful.
How many sand lifting cases you are involved?
My
Entire river. Hold. And इसीलिए each time concentrate will be flooding because the river bed is gone. Yes, next.
I'm for the petitioner, my lord. Petitioner before your lordship is the husband. Allegation under section 498, 323, 307, 509, and 34 of the Indian Penal Code. All other 7 co-accused granted anticipatory bail by the learned court.
You have assaulted.
Allegation is general omnibus in nature.
General omnibus resulting in abrasion, bruise, laceration. General and omnibus allegation resulting in. Huh?
She was assaulted by all. All other 7 co-accused granted anticipatory bail by the
Rejected. We have considered the materials on record. Allegation of assault is supported by medical evidence. Petitioner is the husband. Accordingly, we are not inclined to grant answer.
Within 3 years of marriage.
Grateful.
Next. Netai Ghosh.
Meet these.
Yes.
Well, allegations under 406, 420, continuous business transaction from 2021, 1 crore paid through bank account.
You are Kalimata.
Yes.
You are taking TMT bars but not paying.
No, we have paid 1 crore, 6 lakhs. 1 crore, 6.
Oh, what?
No, I'm just
50 lakhs.
informing your lordship.
Police will collect your 50 lakh. Huh?
No.
Petitioner
but kindly considers the conduct.
very bad.
My lord, in this way, if he continues the
Don't
matter,
supply any further.
well, let him. We have stopped even
Very
after
good. Now
huge dues, my
remainder
lord.
settlement not through police. Petitioner is a dealer. Petitioner is the owner of a shop named and styled as Kalimata Builders, which deals in building materials. The fact he has a running, he had commercial transaction with, it is contended, it is contended, he had a running transaction with the de facto complainant, namely Messrs. Captain Steel India Limited, good supply. There is no initial deception, and the allegations of cheating and criminal breach of trust are wholly unfounded. He prays for anticipatory bail. Learned lawyer for state and de facto complainant opposed the prayer. Senior advocate for de facto complainant contends petitioner had dishonestly induced his client to make supplies running to over rupees 50 lakhs, but payments have not been made. We have considered the materials on record which show there was a running transaction between the parties. Part payments have been made with regard to earlier supplies. In such view of the matter, it is difficult to come to an inference that petitioner had dishonest intention from the inception of the transaction.
Yes,
Mere failure to pay dues per se may not constitute offense of cheating or criminal breach of trust. Under such circumstances, we are inclined to grant anticipatory bail 10,000 to Nonsense. Great.
My lord, I am for the petitioner, my lord, seeking bail on the ground of parity, my lord. Charge sheet has already been
Where is
submitted.
the order?
My lord, page number 8, 7 and 9. Two co-accused.
302.
302 along with
Why
charge sheet.
Named in the 164 statement, my lord.
We have considered the materials on record. Petitioner is named in the 164 statement
has
of
already been
witnesses. Statement of witness before magistrate told
Witnesses, my lord. Other
witnesses before magistrate and police show petitioner and others assaulted the victim with sharp cutting weapons. He does not stand on the same footing with co-accused who has been granted anticipatory bail. In view of the gravity of offense and prima facie involvement of the petitioner in the murder, we are not inclined to grant anticipatory. Next.
Lordship, allegation is this, all the neighbors due to previous grudge, 307, charge sheet submitted.
Page 23, 24 is the injury report of the minor daughter and son by knife.
By knife. Safikul.
Scalp injury.
We have considered the materials on record. Petitioner Safikul.
No,
Saipur. This is Saibur.
Same person. Saibur or Saifur? Saibur. We consider the materials on record, including the injury report. Petitioner had dealt a knife blow on the head of the victim. In view of the nature of the injury, nature and site of injury, we are not inclined to grant anticipatory.
Grateful.
Next.
Great, please, Your Lordship.
Promise to
Well,
marry,
this,
refuse marriage and
service is,
by consuming poison.
Age.
20.
but when the service is not complete. It has
Officer
not
in
been-
charge, de facto complaint. Notify de facto complaint with regard to pendency of proceeding and next date. Suicide, there is no section added.
It has
108
been, my
added.
lord. 108 has been added.
108 has been added.
Subsequently.
Any suicide note has been? Give notice to the complainant. How can you give?
69.
Right, please, Mr. Before you
sorry.
file, see page 2. Will you do planchet and send it?
Well, we have sent it to the correct address. Well,
Oh
I
my
understand.
God.
I understand.
The person is dead. The victim is dead.
Well, it was served upon the de facto complaint was the father, my lord.
So how have you described this as
It's wrong, my
victim?
I'm very sorry, my lord.
Then you
Kindly
write
grant
de
me
facto complaint.
Well, kindly grant liberty.
Liberty to amend.
I'm very sorry.
Behind. This is your
No, no, my lord, it was
responsibility.
absolutely my fault, my lord. I
Next
should have
week,
checked, my lord. Well, liberty to correct, my lord. Next week, okay.
Opposite party number 2 de facto complaint করবে, হ্যাঁ? Next.
Yeah,
Yes,
Your
Devi Priya.
Lordship, there was been a defect, Your Lordship. Is it showing its defect? Is
Yes. We have to authenticate the certified copy.
authenticate?
Defects be removed with full stop, adjourn 2 weeks
2 weeks.
as last chance. Next.
30 arm for the applicant, my lord. I have checked it, my lord. There is one stamp missing. Two
So
stamp is
defect be removed,
my lord,
adjourn.
they want new certified copy.
Give it. Defect be removed, adjourned 2 weeks.
Good.
Take back the certified copy, get the stamp and bring it. Huh?
Great.
Next.
But I have just been appointed.
Defects be removed.
Hello?
Defect is there.
If I think the stamp is not there because in my
Defect
copy
is-
also stamp
defect
is not.
is removed, adjourned 2 weeks.
Grateful, my lord.
Lordship, I am appearing for the petitioner Lordship. In item number 37, Lordship, I am not pressing this application.
Not pressed. Not
Lordship, I'm appearing for the state in item number 38.
Lordship, in item
37 is the application for relaxation. He is not pressing it, so
and
not pressed.
and 38 is also application. He is a son, Lordship. I am praying for relaxation of the condition of anticipatory bail passed by Justice a coordinate bench on.
Report updated.
What is the condition?
The condition is that to report before the investigating officer once in a month till conclusion of the investigation, Lordship. More,
Charge sheet filed.
Lordship, the
charge sheet, the offense is under 498.
Charge sheet filed.
no Lordship.
Not yet, Lordship. He has been.
Do you need further reporting?
Instruction
has been
has been
complied.
given, for filing of the charge sheet, and he's been cooperating as per the IOs.
Petitioner has cooperated with investigation. Investigation is substantially complete. Under such circumstance, condition of anticipatory bail to report to
the investigating officer.
Once in a month.
Once
Wait.
Once in a month,
Once in
Lordship.
a month.
Once in a month.
Once in a month is waived. Other conditions shall come.
Grateful.
Grateful, Lordship.
Yes, next matter.
Grateful.
$39. Give a report. Sonali Das. Give report here. 39. Report adjourn 1 week. 40.
Let 40, my lord, I wish to appear for the petitioner. My lord, your lordship granted anticipatory bail to the petitioner with a condition that he have to meet with the investigating officer once in a week. My lord, he complied with the condition. Thereafter, my lord, charge sheet submitted, and I want to relax that.
Charge sheet has been submitted.
Investigation is complete. Petitioner has complied with condition. Investigation is complete. Under such circumstances, condition of bail to
My lord, page 10, my lord.
meet investigating officer once in a week is waived. Next. Yes.
Your Lordship, on behalf of the applicant in CRAN 2, a CRAN application has been filed. It was taken on the last day, Your Lordship. The issue was the transfer of the case from the NOC, obtaining NOC from the erstwhile advocate.
Who is the erstwhile advocate?
Yes.
So all right, keep the NOC.
I asked him who has given the uncle of the appellant. He has given all the papers to. I asked him to come. I will give it to him. They have not done.
Where is the uncle?
Client is not.
He's in our locality, man. I know.
That I am not aware about that,
All
Your
right.
Lordship.
I do not know them. The person who has given me, I asked him to come. They take it.
All right, you keep the NOC. Bill was rejected earlier.
Your Lordship, so far.
Yes.
Oh, the application is
Earlier rejected.
This is CRAN 2, which is just for change of obtaining the NOC, Your Lordship.
Mr.
paperwork has
Maulik, assures the court that the no objection would be handed over to the learned advocate representing the who is presently representing the appellant. With this, in view of this assurance, application is dismissed.
Great.
Next. Yes. Yes, Mr. Sen.
I'm appellant in item number 45.
I am 44, my lord.
My lord, I am in 43, though I do not have any CRAN application.
Who has the CRAN?
My lord, I have filed. My can is pending, my lord.
Now tell us, what is the CRAN number? Was it rejected earlier?
No, this is the first time. My lord. Earlier rejected his can.
My application was
You stand in the same footing with others. Mr. A.
Hamid.
Same footing with others. How will you have different? But now paper book is ready. What we propose is, let us hear out the appeal.
Oh, my lord, we are not the my lord, factory or we did not product.
My lord, this is a case of spurious leaker. My lord, your lordship may remember, my lord, about 170 persons, my lord, died. My lord, what happened, my lord,
we
as
use-
the present petitioners are concerned, they are just the seller. The
That's
principal
very good.
accused is
The
my lord,
prosecutor case is-
1 second.
The principal accused, who is the manufacturer, the Khora Baksha, is the appellant at number 46. These persons used to buy from him and used to sell. Now, my lord, there are about 56 witnesses in this case. My lord, we are in custody for about 13 years.
13
The
years.
conviction is under section 304 and my lord, 273.
273 is life.
Yes, my lord. So far as West Bengal is concerned, like, my lord, there are certain decisions, my lord, your lordship knows, my lord. Now, my lord, we are in custody for about 13 years.
Very good. We'll hear out the appeal. We'll dispose the appeal. We won't give bail.
Bail petition will not be considered, my lord. 13 years, my lord.
We'll hear the appeal now. What is there? The evidence is whether you were selling the liquor, whether the liquor was spurious. Now, if it is so, then the owner shifts on you to show.
The judgment reflects, my lord. We used to buy from them and we used to sell in the market.
So you very good.
The prosecution case is
all of them, all will be, all are sentenced to life imprisonment.
Yes, sir.
Brilliant. Mr. Mitro.
My lord, item 46.
40C. Oh, you are the main. Thora. Alleged main.
In the earlier rejection, your lordship will find so many appellants they came. Not even single.
What?
Lordship kindly sees the order dated 17th of May 2022. Lordship there, Dukhi Loskar, Khoirul, Khoirul alias Harun, Noor Islam, all these appellants came. Separate appeals.
Right.
Lordship CRA 582 of 18, CRA 612 of 18, CRA 602 of 18, all were turned out.
Now Nojrul has come. Right.
Nojrul ki thought?
No.
So
I am representing
let
Nojrul.
Nojrul face the same fate And what we propose to do is, this is an exceptional case, which is why we do not follow Sodhan Singh and hear out the appeal itself. Right? Who is for state, Mrs.
Mr. Roy is leaving us.
So let us, when do we fix this matter?
No, any day in the first week of December.
First week of December.
First week of December,
Yeah,
आज ये तो शेष ही होएगा।
I'm ready.
10 दिन।
We have
2 weeks.
এই কবে কি ফিক্স করেছি বলো তো?
Date একটা বলো।
Date বলো।
এটা ফিক্স করে নাও। হ্যাঁ,
একটা খাতা ডায়েরিটা তৈরি করো। Some
9th we have.
তাহলে 9 হবে না।
Fixed by the-
what?
Not 9, 10 না।
We are not concerned about this.
My lord.
There are 5 appellants. We'll consider someone else and then we'll keep it for another day. Please give the number.
We have a fixed.
9th December, one appeal was fixed. Supplementary list is যেটা fixed. On 10th. Or we will not 10th. Mr. We keep that was fixed on 9th. Along with that. What we are doing is we keep this on 16th of December.
16th of
all right? 16th of December.
16 December.
তার ভিতরে
Sir,
দেখে নেবো, দেখে নিয়ে written argument
CRA 560.
instead of it's a Monday, can it be on previous Friday or Tuesday? 17th or 13th?
Yes, Calcutta item 67 was fixed on it.
On
13 that thing, আমারও তাই, আমারও সোমবার দিন অসুবিধা।
সোমবার 16 তারিখটা বাদ দিয়ে খালি 16 নর্থ বেঙ্গল।
13th was
Well, let it be
তার সঙ্গে with ছিল।
70. Fixed on 17.
Obliged.
In the supplementary list. Taragilido, we have considered the evidence on record. Large number of persons died by consuming illicit liquor. Appellant is one of the sellers. Prayer for suspension of sentence of other convicts have been turned down in view of the nature and gravity of the crime, where a number of persons had died due to by consuming illicit liquor, and the evidence on record implicating the appellant in the crime, we are of the opinion protracted incarceration of the appellant would not justify release on bail. On the other hand, paper books are prepared and appeal is ready for hearing. Hence, we fix the appeal for hearing in the supplementary list on 17th of December 2020.
extremely obliged.
মানে same order may be passed in item number 45. A CRAN
All
application is-
connected appeals. All connected appeals. Ms. Sinha prepared a chart of witnesses and brief description of their evidence.
Yes.
Miss
Amita.
Next matter.
47 and 48.
47, 48. পেপার বুকটা কোথায়? Okay. Miss Mitra appeared for the appearance. Go through the paper book. Joydeep appear for the state. State, who is there, Mrs. A? Where is he? Huh? You take the paper book. We are keeping this tomorrow. See, 13 years a person is in jail. Paper book is ready. We'll dispose it of based on circumstantial evidence. Principal accused has the witness has turned hostile. Just see what are the other evidence on record, right? The only one of the accused deposed. Is a confessional statement. There is one confessional statement of one of the convicts. Hmm.
He's not well. Some
To appear, huh? Tomorrow we are keeping this, huh? Not today. Nobody appears for the appellants. Miss Mitro is Nimai Chaudhuri. Nobody is appearing. There is Dulal Mondol also. Let there be two persons. Tarin Khan is there? Not there. Nobody is there. We don't find anyone from the. What have we said, Miss Mitro?
Well, I will.
These 3-4 persons. Should
Well,
be-
I will intimate the legal aid.
What will the legal aid do? What about the lawyers? Half of them don't have work. Sit and gossip outside. For heaven's sake, sit and gossip inside so that we can notify, find out and ask them to appear. Because there are two different accused and the defense may not be same. It may be a cutthroat defense. That is why I don't want you to appear for both. You appear for Dulal Mundul. And Nimai, there is Shomo. Where is Shomo? Monisha, you are for High Court Legal Service Committee. So why we are shouting ourselves? Can't you be slightly proactive and say that we are for appear for Nimai? Nobody appears for the appellants, Miss So-and-so and Miss So-and-so, empaneled lawyers for High Court Legal Service Committee, requested to appear. Secretary, matter will appear tomorrow. Same meeting. Next. Confession किया है. Next.
My lord, I'm for the stay.
when it is called. See, don't worry, we will not finally dispose it. We'll see. All right.
Yesterday I missed the bus, my lord.
We will see.
Don't worry.
Your Lordship. Your Lordship, I want to, this is an application for, I want to mention.
Yes,
This is an application for cancellation of anticipatory bail. I would request you to grant leave for filing of this application.
why?
Because the certified copy of the impugned order is not available to me.
Get it and fight it.
Okay, thank you.
Appeal is directed against judgment and order dated Next.
Basically, I am afraid.
Yes.
The paper book is ready. 302, 34, live. Study since 25th of October 2011.
Then.
Judgment delivered on 28th of January 2013.
Then they are in custody for 14 years.
That's it.
Then appellants are in custody for 14 years. Stop. Though sentence is of life imprisonment and appeal is ready for hearing. In view of the direction in Southern Singh, so and so, we are inclined, appeal is, sentence is one of life imprisonment, full stop. Appeal is ready for hearing, but there is little possibility of the appeal being heard out in near future. In view of the aforesaid and the direction in Southern Singh, we are inclined to suspend the sentence. We are bail order. Next. So, next.
My lord, I have been appointed by High Court Legal Services Committee, my lord.
Yes.
My paper book is ready, my lord. I have been handed over the paper book.
What is the sentence?
And the appellant was put on trial on a charge under section 302 and sentenced to suffer rigorous imprisonment for life. Shodamini Mondal, my lord, she is the appellant, my lord.
So what is the conviction? What is the evidence against her?
My lord, the prosecution chose to examine, my lord, 17 prosecution witnesses. Lord, what I have seen, my lord, if your lordship may kindly turn to page 10. Shantanu. It's 19.
Someone pushed the co-passenger from a train.
Yes, my lord. Page 19, my lord. Dr. Shantanu Haldar. My lord, there I could find, my lord, from the evidence that, my lord, may I read, my lord, on that day, Padma Sardar was admitted in our nursing home with a complaint of head injury. My lord, she is the deceased. I examined her. On her examination, I found scalp hematoma on the frontal parietal region. I prepared the injury report. There is a history. As per statement of the patient, he was frequently assaulted by a co-passenger Durga. Durga is not my lord Shodamini Mondal, by a co-passenger. And she was also assaulted and sprinkled some irritating liquid on her eyes by Durga and her associate. She was pushed from the train. There is no eyewitness to the incident that this appellant has.
PW1 Uday Shankar Das, my lord, he is a retired constable. He was posted at Joynagar GRP. He came to know that one lady was fallen from the train. My lord, PW2, my lord, Gaurav Kundu. He is a hearsay, my lord. He went to the spot and heard. Thereafter, PW3, my lord, Anima Panik. There is no eyewitness to the incident that.
Yes, eyewitness is there. Ah, ah.
And my lord, the statement of the deceased, my lord, to the doctor.
Eyewitness is PW3. Anima Pike.
My lord, but the deceased, my lord, stated to the doctor that once Durga used to tease her.
Yes, but she doesn't say Durga through her. Let us see the.
My lord, PW 10, that is Dr. Shantanu Haldar. My lord, he has examined this deceased.
With the 6-second file to the.
Well, Anima Panik in her cross-examination stated that I had no paper to show that I was traveling in that train.
What paper will they have?
My lord,
Local train?
Well, if your lordship may consider PW 10 that doctor.
This lady was arrested at the spot.
My lord.
Then lady was arrested at the spot.
Well, if your lordship may kindly consider PW 10 Dr. Shantanu Haldar.
We have considered it. That nothing. We don't find it very convincing that Shantanu. What is there in Shantanu's evidence that the same person. No, no. Handed over to police on that day. Hmm? When was she arrested?
Well, she was arrested, my lord.
The incident occurred when? Incident
Date
occurred
of incident, my lord, is
10th.
yes, my lord.
10th. FIR is also by 10th.
10th, 10/5/2017.
On the previous day, there was she is named as an accused. There is no injury report is not exhibited. You see the other
Exhibit 4. Where is Exhibit 4? Exhibit 4 injury report. What is it?
And also, my lord, if your lordship may kindly see PW4, Nandarani Mondol. My lord, she was informed by PW3 that Onima that her sister was thrown from the train, but she didn't divulge the name of the appellant to her.
Name they did not know. Name they did not.
My lord, she claimed that she had seen the appellant, but she didn't tell her, my lord.
Fifth file টা দেখি। These people are saying on 10th she was arrested. That is why I am trying to find out how she was arrested and detained. The remand memo will show. I at Joynagar railway station. I arrested the in at the railway station. You see?
When the train pushed her, when the train reached at Joynagar railway station, Padavati Sardar pushed her from the railway.
Maybe her name is Durga.
Hmm.
Cancellation.
Person is arrested from the railway station itself. Then
Well, Onima has claimed that she has seen that lady to push. But my lord, when she have stated PW4, well, if your lordship may kindly sees, Onima told me that the elder sister daughter Padma was thrown from the train, and I reached the said Joynagar railway station to see her. I rescued Padma and took her to nursing home. She was admitted there for 3 or 4 days. After that, she died. Who has thrown Padma? I cannot say her name. Well, if she has seen, well, she could have told PW4 that yes, this is the appellant who has thrown, but she didn't divulge the name.
that lady is present in dock today. PW5 you are reading, no?
PW4,
PW4.
Nandorani Mondol. It is PW3, my lord, who has stated her.
Huh? After that she died. Who has thrown Padda? I cannot say her name. She doesn't know the name.
But my lord, Onima has reported her that one lady has thrown her.
But they don't know the name. They don't know the name of the lady.
But my lord, Onima, what has fallen from your lordship that Onima has seen the appellant through push the disease.
But
if she has seen, my lord, she could have stated, my lord, PW4 that yes, this is the person who has pushed her.
correct, but then that person was there, but they don't know the name. Which is the reason I asked you how the name is appearing in the FIR.
This is
The name is appearing in the FIR, na? FIR
my
is
lord.
lodged by whom? PW? PW5.
PW5.
Because the lady had already been detained at Badipur. If you see the 164 of PW3, they got hold of the lady. Now, in our understanding, is Durga the same name as Shodamuni?
That is a thing, my lord.
That thing you were.
But my lord, Durga and her associates. The deceased has stated that Durga used to frequently assault her, used to sprinkle some irritating liquid on her eyes.
Right.
She has stated the name of Durga.
the issue is solved. Then there's a
Absolutely. This argument was also not made before the trial judge that you are not Durga. Ah, we are not going to take cognizance of it. Because you didn't take up the point that you were not named in the injury report.
My lord.
How long you were in custody?
My lord, since 2017, my lord, he is in custody.
All right. Who's for state? What do you say?
The problem is that my name has been appearing for the state. That's the
So
problem.
so long you were sitting and sleeping, you couldn't have looked into the papers. Your name is entered, your friend's name is not entered. Harmless gorilla like. To the paper book, we keep it tomorrow. We dispose of the.
My lord.
Only one thing is troubling us, and what Ms. Mitra has pointed, there's no reference to Shodamuni in the injury. So it is possible that she did not know her name. If we look into the injury report, there were others also, including one Durga who had sprinkled some substance in her eyes, and then she was pushed. The person who says she was pushed is PW3. All right, good. Keep it tomorrow. Yes, next matter.
Can I?
Miss Sen, there is one lady whom we have asked you to represent in a anticipatory bail application. Sina, Miss Sina, please intimate her, give the particulars so that she can represent. You are in the High Court legal committee. Oh, you are not there.
Oh, then that could have been a problem because we got her. So Troy had taken her to the office and asked her to discuss about the necessary.
All right, if someone else is appointed, fine.
I believe she was there.
Just find out so that she is represented. If not, you be there so that you can do. Yes, next matter.
55.
Lordship, in this matter, I am appearing on behalf of the appellant. He is in incarceration for about 8 years, 6 months.
Very
and the
good.
paper book is ready, Lordship, and also the short notes. Lordship,
We have considered we add it to the list for hearing. We have considered the evidence on record. There are
case is hinges on the
18
circumstantial evidence and last seen together.
PW
18 by a child witness, Lordship.
PW 18 has implicated the appellant, has stated that PW 18 says that they left together
The deceased and PW 18 were coming together. Thereafter, the appellant intercepted. The deceased communicated to PW 18 that you may leave, we'll continue.
PW 18 daughter, son or daughter? Son or daughter? Son of the deceased deposed that she had
Son of the deceased, no, Lordship. Relative of the deceased.
It's a friend of the deceased. PW 18 is a friend of the deceased.
So it's saying the child witness?
No.
Child witness, Lordship. It is depicted at page number, Lordship, 38 of the paper book.
PW 18, a relation of the deceased deposed that she had left with the appellant before the incident, full stop. Postmortem report reveals that postmortem report, PW 10 PM doctor states that death was due to death is homicidal. On the statement of the ornaments of the deceased were recovered from the appellant in view of the aforesaid evidence on record, and as the sentence is one of term imprisonment, we are not inclined to suspend
life imprisonment, Lord.
As a we are not inclined to suspend the sentence. Appeal is ready for hearing. Let the appeal be added to the list for hearing in the monthly, under the heading hearing, monthly list of December 2024.
As your Lordship.
Next. Yes.
Great, this is good. My lord, on the last occasion, it was kept for a report from the jail whether the cancer had relapsed or not. Only limited to that. You have a copy of it?
It's a very backdated report.
Huh?
This report is of June 2000.
Old report. Get a new report.
Time, so we had that.
Get a new report, huh? All right. Superintendent, appellant contents, he is suffering from cancer.
It's suspected.
He is suffering from serious ailment and prays for bail on such score. Superintendent of the correctional home shall arrange for medical examination of the appellant before
Examination to hold it.
in a government hospital, preferably by an oncologist. Medical report with regard to his state of health shall be filed on the adjourned date. Matter will appear 2 weeks hence. Next.
Okay. 58, my lord, I'm led by Mr. Jonathan Chatterjee.
57, I am appearing on behalf of the appellant, my lord. But I have not yet filed any bail in connection with appeal, my lord.
Yes, 58, you have filed bail?
My lord.
Yes, tell us.
My lord, appellant is a lady, my lord, convicted under section 302 and 120B of IPC. He imprisonment for life and fine 50,000.
It rejected earlier?
No, my lord. It's
No.
the first application.
Yes. Who is for state?
She is in custody for more than 7 years, my lord. And she is suffering from kidney problem, my lord.
All right.
Is the daughter-in-law
of the deceased.
Sorry, my lord.
She is the daughter-in-law of the deceased.
That she was
She is residing
She is
the
in the
adjacent
custody
room.
for more than 7 years.
Hmm.
She is suffering from kidney illness for the last 1.5 years.
Hmm.
Dialysis is going on. My lord, kindly takes a report, my lord. And my lord, she was in the adjacent room. But the fact is, there is no allegation, even my lord, on the basis of circumstantial evidence, though this conviction was given, everyone has said, we doubt. Not only that, the husband of this appellant, she died, my lord.
What are the circumstances relied by the prosecution against you?
Yes, only one that she was.
Any article was recovered from you?
One dasha, one wooden stick was recovered. They said that was blood stain, but that was not sent for FSL. Neither blood was determined.
Then,
my lord,
apart from that,
my lord, she was staying in a same complex. Nothing else, my lord. Nothing else. What happened? Why, my lord, this anger?
all this nothing else will be later on. What are the circumstances against you?
Yes, my lord, the relatives, they came running after hearing the screaming. They found the doors were closed from inside. That's
Which door was closed?
my lord, one grill door and one door at the roof. That the door was, there was chitkini, the door was locked from inside. That's why they thought that had it been a case that outsiders came into the room, they did not have fled from the house. Then the doors.
You were the only person in the house apart from the deceased when the murder took place.
Yes. Yes.
There was a minor daughter, my
And the minor daughter, all right, minor
Yeah.
So
daughter.
mine, a 4-year-old daughter committed murder. So please make sensible submission. The only capable person was Oshima
Oshima.
in the room,
No, in the
in the
adjacent room.
house, in the house.
In the house.
And
ये तो judgment के लिए दो.
yes, you get a Mrs. A. Appear for aim. And how Debashish Onao is stolen articles recovered from you?
No, my lord. Only from my position, my mobile phone has been recovered, and I have been tagged in this matter, my lord, as a paramount. I was not present. It has been specified from the version of the my lord prosecution witness, and the conviction has been awarded, my lord, since I did not cite any DWs from my part, my lord.
You have the evidence?
Yes.
Make a photocopy of that, give it to her. Go through that evidence, get a medical report. Medical report with regard to it is contended appellant Oshima Vishwas is suffering from severe kidney ailment and is on dialysis. Report with regard to her medical status be filed on the adjourned date. Adjourned 1 week. Next.
The crimes of the accused. I mean, there are
Yes, next matter.
Matlab paper book is ready.
Added to the list. It was rejected earlier.
No.
Then what is the evidence against?
Matlab everything matlab only one witness, PW1 and
Eyewitness.
doctor PW6.
Eyewitness.
No, doctor and matlab prosecutrix.
One is eyewitness.
376D, my victim.
Oh, 376D.
D. My lord, two appellants, best evidence, behalf of the prosecution, 3, my lord, rape, but not go to, my lord, went to hospital, died after 3 time rape, went to, my lord,
98 304B 8 years. I'm in custody for last 3 years 3 months. My lord, the
Appellant has been sentenced to term imprisonment. He's in custody for over 3 years.
that report and the tenure of my lord. It was called for.
He prays for suspension of sentence. State has submitted report. We have considered the materials on record. Sentence is one of term imprisonment. He is in custody for over 3 years. You for state?
But I'm state, but I'm in the appeal.
Okay, both of you. Under such circumstances, and in view of law declared in Rama Gosai Sinde, we are inclined to suspend the sentence. App will be added to the list for hearing. Next.
সার্ভিস করতে বলেছিল charge was framed alternatively 498 to 304B and 302 conviction under section 490 to 304B life. The wife is the complainant.
Murder.
It is not. It is not. The wife of these accused is the complainant. The victim is
Wife of the accused.
300, not
304B.
302.
Okay. Not 304B.
No. 302. The complainant is the wife of this petitioner. The victim is the mother-in-law. It was alleged that on the fateful day, there was a sudden quarrel between the petitioner's wife and the mother-in-law with regard to a baby, because the mother-in-law wanted to keep the baby in her lap, but the petitioner wanted his son back. So on that score, suddenly incident took place. There was a shovel lying allegedly in the room, and he picked up the shovel and assaulted. But so far, Lord, the medical injuries are concerned, Lord, the doctor who treated the victim at the first instance, Lord, he said that it has been caused due to sharp cutting weapon. Though the shovel was seized, but it could not be produced, no FSL report. It was on.
How many injuries were?
Lord, the injury was, it says, Lord, few. Your Lordship would kindly see the postmortem report on my lord today.
Then,
but blood sudden provocation, blood.
How many?
I'm in custody for 10 years, 5 months. No previous rejection, nothing.
Is ready.
But at best, Lord, subject lordship kind sanction, Lord, at best 300 for. How? Because few features, Lord, I'll just try to explain
That
that.
few features will be after the paper book is ready.
Because sudden provocation.
Paper books will be prepared within 4 weeks. Let the matter appear in the monthly list of January 2025. January 25 we will consider.
But can it be in the next?
Finally dispose of this matter. Let the paper book be ready. If we are with you, we will sentence you to the period under. If you are not with you,
even I was praying before your lordship that, because other features which I was saying, PW14 is a person who said that he heard that the girl has assaulted.
Correct. We need to see that in perspective of all the evidence. So when the paper book is ready, we will see all these things. Next.
But can it be in the next month? Let's submit lordship and sanction.
No chance. Paper book has to be prepared. 4 weeks will be required. It's just LCR as. Next.
May I please your lordship? Your lordship, 10 years term imprisonment. Your petition is in custody for 8 years, 8 months.
Appellant is in custody for over almost 8 years, 8 months. Maximum sentence imposed upon him is 10 years. He has served out a substantial portion of the said sentence. In view of the aforesaid, we are inclined to suspend the sentence. There is no possibility of the appeal is of paper book ready. Though paper book is ready, appeal is of 2023 and there is little possibility of the appeal being heard out in near future. Sentence suspended. Next.
98 is sentence for 2 years, 304B sentence for 10 years. During trial on bail,
Cause of death, consumed poison. As
Alright.
per PM doctor's
Appellant,
opinion,
we have
antemortem.
considered
No.
the evidence on record. Appellant has been sentenced to term imprisonment. He was on bail during trial and did not misuse his liberty in any manner whatsoever. No aggravating circumstance is placed on record in view of the aforesaid facts and the law declared in Shinde so and so. We are inclined to suspend this evidence. Next.
Grateful.
Paper book be prepared within
64.
6 weeks. Law court record.
Well, the bench did not sit because the Chief Justice determination is taken by Justice Tandon with Hiron my watcher. So my could not be here. My it was rejected. I don't fall within the category. Well, fix it in the month of January.
I appeal in view of the evidence on record showing recovery of narcotics above commercial quantity, suspension of sentence was turned down earlier. Paper books have been prepared and matter is ready for hearing. Hence, we are not inclined to suspend the sentence. Let the matter appear for hearing in the monthly list of January 25.
Grateful.
Next.
Yes, my lord. I am for the appellant, my lord. Last occasion, my lord, on 15th April 2024, your lordships, my lord, directed the department to prepare the paper book, my lord, when the application came up for hearing, my lord. But I think, my lord, no paper book has been.
Latest. Two weeks they'll come. Paper books be prepared and placed before this court on the adjourned date, adjourned 3 weeks. Next.
Madam, my lord, conviction under section 4
He's a married person. He's not married. Consider the evidence on record. Narcotics recovered. How long he is in custody?
He's in custody. During trial, he was in custody. Total 5 years, 2 months.
All right. Appellant is in custody for 5 years, 2 months. Sentence is one of term imprisonment. That is 10 years. He has suffered more than half of the sentence imposed upon him. The paper books are not ready, and there is no possibility of the appeal being heard out in near future. In view of the right to speedy justice under Article 21 is applicable in appellate proceedings also. In such view of the matter, we are of the opinion appellant is entitled to suspension of sentence on the score of protracted detention, that is which is more than half of the maximum sentence imposed upon him. Suspension of sentence / bail on the ground of delay is not restricted by fetters of Section 37 of NDPS Act. Suspended. Allowed. Next.
It's a case of 2012. She was in
Next.
custody for 2 years.
Defects be removed.
The case of 2012, punishment is 10 years.
Ah.
During trial, she was in custody for 2 years, 7 months. And then trial lasted for 9 months. 9 years. She was on bail for 9 years. After conviction, 1 year. Total 3 years, 9 months. Maximum punishment 10 years.
5 and 6 of Immoral Trafficking Act. The appellant, before you are the mother of the minor victim.
No, she was major, actually. She ran away.
Minor at that point.
Now we will not give
She's
you.
married.
After 5 years,
I just a minute. She ran away, so she lodged a missing complaint. Now she has come back. She got married.
Department is trial court record has been.
House.
Department is directed to examine the records and give a report on the urgent date. Matter will appear 3 weeks hence. We are not disposing of your application for suspension now. Next.
After 3 weeks.
Please.
My lord, NDPS out of 10 years, 7 years, 11 months.
7 years, appellant has suffered 7 years incarceration out of maximum sentence of 10 years imposed of him in view of the protracted period of incarceration already suffered by the appellant, and as the appeal is of 2024 and there is no possibility of the appeal being taken up for hearing in near future, we are of the opinion appellant has made out a case for suspension of sentence slash bail on the ground of delay. Suspension of sentence slash bail on the ground of delay infracting right to speedy justice under Article 21 of Constitution is not restricted by fetters of Section 37 of NDPS Act. Accordingly, sentence is suspended, appellant released on bail. Next.
Lordship, originalটা দিয়ে দে।
Allowed conviction under section 364, 302, 401, the Indian Penal Code. Sentenced to imprisonment for life during trial in custody. Now he is in custody for more than 6 years, 6 months. One of the circumstantial evidence. One is, my lord, the leading to, my lord, the statements of the accused. There was a recovery of dead body. Now it appears from the evidence that recovery is prior to their arrest. My lord, page 6, last paragraph of the judge. Now, this is one. Another is, my lord, the recovery of Gamcha leading to their statements. Now, from the, my lord, the exhibit, the statement, it appears that is a post-recovery statement. Post-recovery statement. My lord, that is page 13, third paragraph. And, my lord, the last thing together,
We have considered the evidence on record. Appellant was last seen with the victim prior to his death as per PW7. Full stop.
PW24.
Incriminate.
PW24.
From the evidence, appellant was last seen with the victim prior to the death. Incriminating articles have been recovered from them in view of the aforesaid evidence and the nature of crime. And as the sentence is one of life imprisonment, we are not inclined to suspend the sentence. We direct preparation of paper book within 6 weeks of receipt of law court notes. Yes, next matter.
As for the appellant, Lord, your Lordship, Lord, on the other coordinate bench has called for a report since the petitioner is suffering from HIV, and your Lordship, Lord, while your Lordship was has observed, Lord, to take necessary steps in respect of the appeal of this appellant, considering the fact that he is suffering from HIV. Lord, I have annexed your Lordship's, Lord, judgment, Lord, at page.
What is the report?
Report says that he is suffering from HIV.
Medical report is placed on record. Report shows appellant is HIV positive. In order to enable the appellant to avail better medical treatment, we are inclined to suspend his sentence purely on humanitarian considerations.
Obliged.
Allowed. Okay. Let the matter appear for hearing in the monthly list of December 2020.
Obliged. CGM Purulia. Lord, is file an application, Lord, after your lordship has observed in that order. Lord, already, Lord, pursuant to the order of the other coordinate bench, Lord, I have removed the name of the petitioner and I have described him as X. Since, Lord, this has surfaced that he is its affected person. इतना आसे